time it hit me, and I was just really feeling bad about it. And I don't even know how to explain it. It's just, and then like, just explaining it, it's just like it's it's bringing back like the stroke. Like anyway, it's yeah.
Yeah.
Anyway,
Well, you got to remember that a lot of people are going through that because it's a mental thing and they're thinking that all these bad things are going to happen, but it's not really, not really true. You have to realize we've been brainwashed. They've been telling us all this stuff like, oh, yeah, the climate bullshit, and now Bill Gates
ultimately,
finally admitted
how is everything going to change though? They have
that
the whole world.
it's not as bad as it looks.
Well, I don't know, man.
I mean, look, you've been living out there in your shack where you're at. You're doing your thing. You really hasn't. Nothing's really changed for you dramatically except your stroke situation. The world is. They've been feeding us lies, and really, when you realize, and I didn't realize that all this time through the Federal Reserve banking system, those guys that started it and set it up, they've been raping our country and giving it all to the world. And I didn't know that. I thought we were, doing good and giving them stuff. They've been ripping us off. We should be so wealthy that it's unbelievable. Like in the end of the 1800s, way
Well, that's
just
what it is.
abundance, abundance,
We
abundance.
all we all we have ultimate wealth. The people of this country have, we basically made it. We should be basically relaxing now and having the government pay us to live basically.
Well,
And that's what's going to happen now. And so,
yeah,
but they're acting like they're the reason that we're still alive, and they're going to, you know, allow us to live, but they're going to tell us how to live, and
uh
they're going
huh.
to tell us where to live, and you
But
know,
they're getting arrested now and they're getting exposed now, and
I
it's all being exposed. And here's the thing:
don't
you can
believe it.
look at it and
I
shake your
don't
head
believe it.
yes or no. You can look at it and shake your head because, again, look right at where you're at. Everything you got, you're doing your thing, you got your stuff. It's exactly the way it was when I met you 10 years ago. It hasn't changed for you on a big economic scale. What's going on with China or any of those other countries, we don't know. And we felt it only through economic strife that we shouldn't have ever had. But the Federal Reserve that created all the fake money and all the fake debt, they used all that against us psychologically because now they're being exposed, and with the way that the system's running now with trade tariffs, hey, shouldn't the tariffs have increased the prices of all our stuff? Well, basically it hasn't, even though inflation's going up for the stuff we buy, food, but not gas. What's going on? How come the prices aren't the way they're supposed to be? Supply and demand, because they never were, and we were taken over, and we didn't know. We just kept working, and so really the system is changing, and it's going to change radically and for the better. I mean, that's a viewpoint that you can accept or reject, just like the viewpoint you came up with. Things are getting bad, the whole world's going to end, which they've been telling us. Shoot, climate change, remember in the 80s? Oh, we're all going to be dead in 10 years. Well, the 90s came and that didn't happen. Oh, we're all going to be dead in 10 years. Oh, it's all bullshit. And now it's exposed, and on all levels.
Yeah, we'll see.
Yeah, well, we'll see. And and the knowledge and the AI bullshit, we know that only is just a faster computer, and that's good. We can get our information quick. It's allowed us to communicate and allowed us to investigate and find out what the real answer is. Because I see people on the internet now, they're saying exactly what I'm saying. Hey, I did all the studies, I went down all the rabbit holes, and I did this, and you know what their remedy is? Well, we all got to get together, and we got to go against Congress, and we got to put in all these notices. Well, we were trying to do that from the beginning. That means go sign up and be a congressman and vote. Okay, that ain't the answer. It might be, because I can always say it might be, but what about taking the heat in court? Where's anybody's remedy to take the heat in court? Because if you can take the heat in court, you can go out and get all these traffic tickets and get rid of them. That's all.
All right, I sent out another message explaining to people that we have 5 people and we need more. So we'll wait another 5. We'll wait until 6:15. We got.
All right. Well, look, I see Dennis. He's here.
I got Richard.
Have you been getting my emails, Dennis? Okay, good. Yeah. And I know Tori, he's on that list. I don't know if he's getting it, if he's signed up. So I signed everybody up anyway to come in. I see Richard's there on the phone. And Harry, I know Harry. I don't know if he gets my emails, and I want to invite him to sign up. Of course, starts tomorrow morning at 10. And I'm going to just go down and start in the beginning and show the way I think, because I see that people aren't thinking. They're getting information and they're basing all their thoughts about presumptions on presumptions, because presumptions are what's put in these complaints and stuff. And if you react upon a presumption, then you didn't rebut it, and now you're engaged in something you didn't need to be engaged in. And it's just that simple. We don't. When you understand, as everybody says, these are administrative courts. Okay, well, what are administrative courts? We got to define that, because that's too general. The court that you're in when you're a defendant in a traffic ticket, it's an administrative court. Okay, when you're in an unlawful detainer, you're in an administrative court. When you're in a mortgage case, you're in an administrative court. Okay, and what does that mean? What is an administrative court? Well, you can, when you go and define it and look at it, it can mean a lot of things. But to me, it means a court that doesn't have the power to make a decision in the case. They'll go ahead and make the decision, okay, if you let them, but they don't have that power. See, and that's where you got to understand the word jurisdiction. Do they have? You could say they don't have jurisdiction. Well, technically, they got jurisdiction over any case in the state. That's a general jurisdictional thing. But the power to act, the power to exercise that jurisdiction is another thing. And this is where people misunderstand, the ones that are trying to write the bar or write anybody and tell them that the Supreme Court has jurisdiction because any case that is in front of that has a state as a party, that the Supreme Court has original jurisdiction. Okay. So you look at that and you go, yeah, that's right. And you want to jump on board? Well, guess what? What is the difference between a case and a suit? Because it has jurisdiction over all cases. Law and equity, admiralty, and for those that which a state is a party. Okay. And those are for jurisdiction over cases. But it's not suits, and a lot of these actions being brought by district attorneys are suits. So you have to determine if you are involved in a case or suit, and everybody uses the words interchangeably, but that's not the way that a judge or systematically, you're either in a case or a suit, and that's the difference. That's why in the 11th Amendment they had to clarify that. Because when you look at the Article 3, the judicial power shall extend to all cases, law, and equity. Then they go on the 11th Amendment that the judicial power is not to be construed to extend to any suit in law or equity. So I had to figure out what's the difference between a case and a suit. And they made the distinction on the 11th Amendment. That's what the 11th Amendment's about. So when you don't know that, then you don't know, then these guys are getting people to put in affidavits. And then again, what's an affidavit? Well, that's just, someone appearing and sending in a piece of paper. Okay, that has influence. I remember I was in court, and actually, I got busted with the same guy, and he was there, and I gotten dismissed because I put in discovery, and it turned out that they wanted to dismiss me from the case, and but before that happened, after the judge allowed me to be pro per, the assistant district attorney, after the court case, he comes up to me and he says, or I go to him and I go, well, what are we going to do now? And he says, well, I can't really talk to you because you're a defendant, but I have to talk to you because you're your own attorney. And I said, okay. I said, oh, by the way, I think I know the district attorney, because he was in the Libertarian Party in a different county, but 10 or 15 years earlier. And so I said, hey, I might know him. And he looked at me and straight away and said, that'll get you off. And I'm like, oh, okay, whoa, that blew my mind. He goes, let's go up and see him. Well, we went up there and he wasn't there. And I never did get to see him. But see, after that, then my buddy, he was on trial and there was a hearing. And I went to the hearing with my friend, and I like to sit in the back. There was no one there. And we sit in the back and we get right in the middle, right? And we're sitting back there. And the judge says, who are you for? He asks us, who are you for? What side are you on? Because we weren't sitting behind the DA or sitting behind the defendant. And I'm thinking again, like, what's that matter? We're just here to watch. And so I'm like I'm being real the way I am, And so I go, we're for the prosecution, And then they go, okay. And then at the break, it was a small town, and we were walking across the street. Me and my friend and the assistant DA, he pulls up, and he had said, I can't remember if this was that same hearing or not, but it was a different hearing. Okay, well, anyway, so that showed me, why does it matter what side we're on? But another part of the story, when we were then again at the next hearing, we were sitting there, and I'd already been dismissed from the case. And then one of the investigators comes over and he sits down right next to me, and he says, hey, I want to talk to you. And I'm like, I don't want to talk to you. And he goes, come on, let's go out. No, I don't want to talk to you. I'm not talking to you. Because I thought, what are you going to do? Start up the case and put me back in it? I don't know. And so then at that break, we're across the street. The assistant district attorney was in his car. He drives by and he goes, hey, I'm sorry I sicked my dog on you. That's his investigator. Sorry I sicked him on there. but it sounded like you wanted to turn on your buddy and testify against him just because he had heard me in the back say, "Oh yeah, we're for the prosecution." So it does make a difference to them. If you got 100 people there, that makes a difference, but not enough to change the course. It's just like, oh, I'm being watched. I need to, we can't, we got to be more strict in our behavior and that kind of stuff. And so these people that are sending in all these note affidavits, it's like I said, okay, yeah, you can send an affidavit, and it really doesn't matter what you say, and it doesn't really matter if it's under oath or not. You got to put it under oath. What do they have to say under oath that's going to be relevant to anything? But it is saying, hey, we're out here watching. And it does send a message, but not the message they think it's going to do. And I don't think they're going to get the remedy that they want, which is, to have the Supreme Court declare that all cases that have the state involved are all void because the state wasn't it wasn't heard in the Supreme Court. So these presumptions that these guys, they're smart, they got an understanding of a lot of things, but there's just that one little flip at the end that they're not quite getting when they're conflating these words. So that's where I'm going to start with talking about words and definitions and those kinds of things like that. And there's no charge for it. I'm going to ask for donations, but and some people have, and I'm going to try to over deliver because there's I see the direction and how it works and what where people are messing up, because and then they're like, oh yeah, don't tell me. I said, hey, I made all those mistakes. I made the mistakes, more than once, over and over again, but then I learned from them and I put them in the toolbox and realize what's happening. And it's once you learn it, then you got to understand what it is. Took me a while to figure out, because everyone's going, yeah, you got it, what you're talking about. I'm like, yeah, but I don't know. But then you finally realize, oh, and then I get the picture. And saying, and it's really understanding a court. And really, even when we talk, everyone talks and says, well, they can't do this, they can't do that. Well, if you're talking about they, and you're talking about in the courtroom, the judge, or, what's going on, is you're not, it's too general. You got to know what hearing you're in. What specifically, what is the hearing going to hear? What's emotion, and why they listen to everybody talk, but the court can't hear what they're saying because they didn't put in emotion. So you said all that stuff, but it was never heard legally because you didn't move the court. And a lot of times you'll see that the DA will go, blah, 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 and this guy, and he that, and this, and he did all these things, which is really, that don't matter either. It's a matter of what the paperwork said and what the motion is. And then the other side will come in and go, well, I this and this and this, and I this and this and this, and say everything against what the moving party said, the DA, and then the judge will totally ignore him and rule against him because the moving party says, I think we should, allow this into evidence, maybe. Okay, for example. And they go, judge, that he didn't this and that. Well, all that means that you agree. You agree with what the guy said because you never made an objection to it, and then gone a direction of why it should or shouldn't be introduced. They attack the judge. They attack the lawyer. But none of that's heard because it's the system and the process is designed basically that the moving party wins. If you put in a complaint against somebody, well, everybody generally, and the presumption is he's guilty, or the complaint should be granted. Okay, well, but then the judge says, yeah, that's right, I agree. But he looks over to the other side and says, well, what do you say about that? What do you say about that? So you have to say something about their action. You can object to the action, or you can answer to what they said. And that's the two takeaways of how you respond. You can either respond to a complaint, or you can answer to a complaint, generally speaking. Say, and they don't even know what the difference between a complaint and a petition is. Okay, and so now they're all down this road thinking they know something, and then they're just going, and they're never heard because they didn't come into the court properly. You got to have paperwork to be heard. You can say no, blah 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 blah, but their paperwork said, this is what happened, and you can either say yes, it did, or no, it didn't. Or you can say that the court can't hear this case. And then to say those things, you have to be able to do it on paper. And for instance, in California, you can only respond, or you can answer. And the way you respond is called demur. But at the federal level, in some states, they've abolished demur. And you can use a motion to dismiss. Okay, but those are the only responses you can make. Otherwise, you have to answer. Okay, now if you answer to a complaint from a traffic ticket, you're going to be answering to a complaint that is insufficient on its face to give the court authority to hear it. But if you answer it, then they're going to go ahead and hear it. Because the answer to a speeding ticket is guilty or no contest. Hey, I can't contest that. The cop said I was speeding. You know what? You probably were. There's corrupt cops, but you probably were. But again, even if you were or weren't, he can't prove it. He can't prove it. So if you allow the court to hear it, then they're going to hear it and you're going to lose. Oh yeah, but if you can prove you're innocent, that's when they listen. So yeah, you can come in with certain ways and certain defenses, but then you can also go through that process, and when you get to trial, then you can put in a motion to suppress the evidence and the testimony and not let the cop take the stand. Because why should he be able to talk? But this motion to suppress, yeah, you have to make that according to the statute. And the statute says that you can't let evidence in, you can't have testimony heard that's been obtained without a warrant. So it's all about the warrant. It's all about, and that's what the administrative court is. They can call it a traffic court, they can call a ticket an infraction, but administratively, it's a court that doesn't have judicial power. And it can't hear the case because the complaint, the ticket, it doesn't state facts that constitute probable cause. Okay, but because it's a probable cause court, not a criminal court, probable cause court. But if you say that they didn't state probable cause, that's not going to work because that's your opinion. But if you state that they didn't have a warrant, now they either did or didn't. And so if they didn't have a warrant, then they can't proceed in that case because it's the complaint didn't have a valid statement of a crime. So the court couldn't hear it because speeding's not a crime. Running a stop sign is not a crime, but you can try to explain your way through that and they're not going to hear it. But if you just flat out demur or move to suppress the evidence based upon no warrant, and then you got to remember, and here's another thing that I learned, or just kind of, you figure out, is the scenario of say they got a warrant. Okay. Well, okay, say they got a warrant. Now here's how they get warrants. The cop or the DA goes into the judge's chambers. He tells the judge he's got probable cause and he wants a warrant. Okay. Well, the cop doesn't really know if he has probable cause or not. How would he know? How would you know? How would I know? We don't know what probable cause is. We're not judges. Only judges know what probable cause is, but we can guess, just like the cop guessed. So the judge says to the cop or the DA, you're certified. You're a certified officer of the court, or you're a peace officer. You're honest. You tell the truth. So here's what I'm going to do. I'm not going to read it. I'm not going to read your application. I'm going to believe you that it's in there, and I'm going to issue the warrant just on your word. So now we have a warrant that's issued, and it doesn't have the probable cause in it. The cop thought it was there, but it isn't there, and any judge that reads it's going to see it's not there. But he signed it, so the real deal is, well, that everyone goes ballistic. Well, wait a minute. The judge says, this is me being the judge. Now I'm going to sign it without reading it. You know why? Because I know that defendant that you serve it on, when he gets in here and when he comes in, he's gonna tell me that it doesn't contain probable cause. And then I'll have to look at it. So I'm not going to look at it until he tells me to. That's his reasonable stuff. He's busy, he's da-da-da. So that's why you're coming in, your motion to suppress. On what grounds? Well, on the grounds, one, there's no warrant. And the second, if there is a warrant, well, there's a warrant, but it doesn't contain probable cause, Judge. Oh, what? Let me see. Because he's the judge. And then he sees, oh yeah, there isn't any. Okay, no, can't put it in. And so really in the beginning, when you go into challenge jurisdiction by demur or motion to dismiss, you're challenging the jurisdiction of the court. Okay, and you put your grounds in there. And then you're basically saying, okay, Judge, you don't have jurisdiction, and I want you to decide if you have jurisdiction. Because that's a general basic requirement of any judge of any case, to determine their jurisdiction. But they never do it because they presume they have it. So they're never going to look until someone asks them to look. And the attorney is never going to ask them to look. I mean, rarely they do to get rid of it, but they want the revenue, because all cases across the board are put in for lawyers to make money. That's the whole deal, no matter what it is, And even in pro se litigants, they're making the other side guy money by putting in, by just making motions and making them answer. So it's all about making the money for those guys. But the minute the judge has to determine, now he's got to determine whether he has jurisdiction or not. Well, some people ask him, but then they keep going on and on and on and never let the judge answer. You don't have jurisdiction, blah, blah, blah. These guys, you're against me. I got this right and that right. Okay. And remember, the judge says in those traffic courts or administrative courts, don't bring the Constitution in here. Oh, you know why? Because it doesn't apply. What applies is the pleading paper, the complaint has to be sufficient on its face to give the court jurisdiction. Well, Judge, look, I want you to open up the file and look at the complaint and determine if it has jurisdiction. Okay, that you ask him. I mean, if you know what you're doing, you can go and just do that, and then he'll decide, and then maybe you'll have to go put in a demur and make him decide on paper, so we know that. But then, okay, he's going to decide. Well, you know what he does? Yeah, I got jurisdiction. Well, he'll say that 99% of the time, but if you are specific and tell him why he doesn't have jurisdiction, because the ticket doesn't state facts that are sufficient to constitute upon which a warrant would issue, in 853.9 of the penal code, then he's going to look at that and then he's going to have to think about it. Okay, so then he might, but 99% of the time, he's just going to go, yeah, I got it. Okay, so now he says he's got it. So at that point, no, we don't appeal because you can't appeal that, but you can do a writ. And then they've even written it into the statute, 1085B. If you have a traffic ticket, a misdemeanor, that you can do a writ, and that goes up to the court, upper court, and you got to know what an upper court is. It's a superior court. And I don't mean the superior court. I mean a superior court to that inferior court, to the tribunal, to the administrative court, the traffic court, or the unlawful detainer court. So that writ would go to the superior division, the appellate division of the superior court, not necessarily to an appellate court. So you go to the court that is superior to that court, because that's what 1085 says. Any court superior court can hear it, and then you petition and you ask them basically to have the lower court judge show the jurisdiction, and you do that by saying that the upper court or the lower court that he was in, the judge, he abused his discretion. So he has discretion to take jurisdiction or not. And if he does, then he's abused his discretion. It could be an error, but not really. Errors occur in the trial, I think. But anyway, it's abuse of discretion to take jurisdiction of a case that you don't have jurisdiction over, but you have discretion to do it. And then you tell him, hey, they abused his discretion. He took jurisdiction. Now bring him in here and make him show that he has jurisdiction. Okay? And that's all we want. Show your jurisdiction. Because the jurisdiction is on the face of the complaint, the face of the initial pleading. And it's not there. It's just not there. Okay? And you can hear me say that, but you need a judge to say it so that the case will get dismissed. And that's the process. Just, have them decide. So you don't care what they decide. You just want to make them make the decision, because everything's operating on presumption there. You want to rebut the presumption, and most people don't know how, even though they know they need to or want to. So that we just have to learn the game. It's and it's a game. That's another thing. You got to realize it's a game, and it takes and it's a debate. And that's why in debate, one side says something and then they are done, and the other side said something. You don't talk at each other and just start, saying this is that and you're wrong or you're right. We just get too emotional. A lot of people do. I did all that stuff. I went through the whole thing. But as you do this, you got to step back and remember that you need facts, which is evidence, and you need direction and an understanding of the authority of the court that you're in, because the cops just going, hey, go see my big brother. Here, go see my big brother. He's official. Oh, okay, yeah, he's official. but he doesn't have no power. He's official, but he doesn't have any power. I know that. So I can argue with the cop, get my window broken, get arrested and all that, or I can just go over to his big brother and say, "Oh, you're the big brother. Okay, well, show me that you got jurisdiction to hear this." Based upon what your brother wrote, not what your brother's paying you, not what you guys talked about at dinner. Look at what he wrote. It's not sufficient to get in. Okay, so we kind of need to know what constitutes a complaint, a sufficient complaint. Because people write complaints and then they're 10 pages, 20 pages long. But you look at a DA writes a complaint. If he ever writes out the complaint for the ticket, it's like one paragraph, right? He did this, he did that, and he did this, and then the verification, and then and what is he verifying? The allegation, the presumption that's on the paper. But the paper never states any facts that constitute that a warrant would issue upon. Speeding, a warrant wouldn't issue because you're speeding. People speed all the time. That's not a criminal offense, but it's an infraction in their mind, and so then they're going to put you into the process. So again, what constitutes a complaint? Well, a complaint is simply a claim for relief, a right to that relief, and a short, plain statement of the jurisdiction of the court. 3 things. And the DA writes a claim. He doesn't even write a claim for relief. He doesn't say he wants $20 or $50 or $100 or anything like that. Sometimes they might do it. But so what's their claim for relief? They're not asking for anything. What right do they have for relief? They don't have any right to relief because you ran a stop sign or were speeding. They don't put it. That's why they don't have any right to it. And where's their short, plain statement of the jurisdiction of the court? Well, they don't need it if the court already has jurisdiction. Does the court already have jurisdiction? Well, it's in the county. Oh, yeah, but we're not talking about that kind of jurisdiction. We're talking about the power to make a decision. Okay, so now we got all that, and then we go into the court, and now and let's look at what happens in there. So, okay, yeah, you're guilty of running a stop sign. Okay, you ran it. I mean, you can say you didn't. You can say you did. He can say you did. He can say you didn't. But let's say you're guilty, and they're going to find you guilty. Okay, so yeah, I'm guilty. I was speeding. I ran the stop sign. Okay, talk to you later. Oh, wait a minute. Wait a minute. I got an idea. New idea by the judge. New idea by the DA. We're done with that, but we got a new idea. Why don't we just fine you? Why don't we just fine you? Like, charge you some money. Let's just take your property, right? Money's property. Let's take your property. Oh, well, judge, if you want to do that, you're going to have to give me due process. Now, so what you're claiming relief. Now you want money. So what's your right to that relief? And what is the statement of jurisdiction that you have? Say, that's why when they find me guilty, I walk out. Oh, okay. Whatever you say. Are you done? Okay, yeah, we're done. I walk out. Oh, and because I said it that way, the bailiff comes out. Are you going to sign the judgment there? No. You sign it. No, I can't sign it. Oh, okay. No, I'm not going to sign it. Okay. Goes back in, talks to the judge, comes out, the judge said, you're supposed to sign this, blah, blah, blah. Okay. Well, no, not going to sign it. Goes in, comes back out, third time, dude, I'm not going to sign it. Talk to my friend here. We got 20 people out here. I'm trying to tell them what happened in there, that nothing happened. It was a big drama show. And now you're concluding it with coming out here begging me to sign this document. Well, what does it say? Let's look at it. Oh, down here at the bottom, to the sheriff. This is your authority to execute up above what the clerk marked up above, that I'm going to pay $150, or I don't know what it was. Speed, ticket. Oh, a ticket for no driver's license. Anyway, whatever it was, I think it's $1,200. Okay, so okay, not going to sign it. Oh well, okay. So nothing. Oh wait, got a letter from collections. Okay, collections, right? Department. Oh, yeah, well, okay, how are we going to handle collections? Oh, well, okay, if you if you have an order to collect, then send me the order to collect. And if you don't have an order to collect, then then you're committing a misdemeanor. Okay, so don't talk to me anymore. They never heard from him again because they can't collect. They don't have an order. No order. And that's what they need to do anything. Need an order. What's an order? A warrant. An order is a warrant. A warrant. An order. You need an order from the court, from a magistrate of the court, from the court. And that's what they need to do anything. To do anything. Okay, so everything they're doing, as we know, is without authority, but we don't tell them and properly put it before them to make a decision if they have the authority. Do you? Do you have the authority? Show it. Where's the warrant? You got a warrant? Yeah, we got one. Okay, well, let me see it. Let me see it. Okay, well, they'll detain you, whatever. Okay, but you're going to see it, and then you're going to see that the warrant's invalid. Now you have an invalid warrant. Now you have an arrest without a warrant, and now you can proceed to go against them. But you got to beat them first, then you can go against them. It's like you have to make your objection before you do anything. I don't know about. We used to play a game when I was in grade school. It was called Mother May I. And the teacher would stand up in front of a line of students and say, Johnny, take 6 steps forward. And he'd take 6 steps forward, and she'd go back. Why? Because you didn't say Mother May I. And that's this game. You got to, if you have to object. If you don't make your objection, then you agreed. If you make your objection, that stops everything. But if you don't come up with a new direction, then they're going to proceed in the same direction they were proceeding after your objection. You have to have something that to present for your objection. So, that's what I figured out, and that's how I look at things. So you got to take any situation and deal with the particular case. People come, oh, what do I do about traffic ticket? Well, yeah, well, generally I can tell you, but what your ticket, there's so many things you can do, you'll get confused on what you can do to get it dismissed. Traffic tickets, you can do declaration by mail. You can demur. You can go through it and put in a motion to suppress. There's all these things you can do along the way, and but if you want to stop it in the beginning, you can do that. If it doesn't work, you can do other things. And then I found that the traffic court is the same as the unlawful detainer court. It's the exact same thing. The first time I went in and saw that, I said, "Hey, they're just doing the same process." And then this one, and I was new at it, and the lady asked me to help her for her unlawful detainer, and So I go up there and I sit down with her. And it's a commissioner hearing it, right? It's commissioner, not a judge, but it's a commissioner. And he knows me. I've been in front of him on all the traffic tickets. And he says, "Are you an attorney?" And I go, "No." And he goes, "Well, you have to go back sit in the back in the audience." And I look at him and I smile and I go, "Oh, okay." And as I'm halfway down, he says, "Wait a minute. You can sit there, but don't address the court." Say, and I don't like to address the court. Now I know that I could if I wanted to and talk to him and
But what was the reason? What was the reason for him to tell you to stay?
yeah, that's a good question. The reason why is because if remember we're in a unlawful detainer case. It's a speedy thing, 5 days. They want to get her out and this and he knew that if he denied her assistance of counsel, that I was going to raise that issue, and that would delay everything, right?
Yep.
So that's the reason why he did that.
I just wanted to make sure you explained that.
Okay, yeah, because it's when they know you know the process, then they just they fold. But and they're testing to see. Some people are close, and then they test, and if you don't get it, then they're just going to proceed because you didn't know. And then they test all the time. That's what they do. And so it got to the point where when I like to go in and just watch. Like I said, I used to go in the middle and sit down and watch in the back. Well, then it got where I walked in the court and the judge stops everything and says, "Bailiff, what's he doing here? Why is he here?" And then I said, "Hey, I'm just watching. I'm not, I'm not, I don't even know any of these cases. You know, I'm just watching."
How much longer are you going to go on for, Zeke? Because we're
I'm,
almost at 7 o'clock.
I'm just rattling to see. I wanted to invite Tori. I don't know if he got an invitation to it.
No, I got the invitation.
Oh, okay.
Yeah,
I meant, I was thinking about
everybody here got the invitation.
the biscuit, Harry the
Oh,
biscuit, but he dropped out.
Harry left. Yeah, Harry
Yeah,
left.
I did want to get him because I don't think I had his email.
I'll send it to you.
Okay, that'd be great. Yeah, I'm done. I mean, we're just talking.
Okay. Yeah, I just wanted to make sure that you got all the questions or the answers. And does anybody have any questions at this point for Zeke? Anyone?
There you go.
All righty.
Yes. Yeah. Yeah. Because like with the stuff I'm talking here, it may come up later on in relating to some of the stuff that we would be talking about. But yeah, I'm not going to really talk about this. Yeah, it's going to start with the words and what they mean and generally and what courts, what is a court, and the different kinds of courts. I think the fifth class is on that. The third class is on traffic, and a traffic stop. You're in a court if you realize it, and you can take control of the court, and you can take control of the cop. But the fear and people and not knowing. See, the key is when you know, then you can control. It's the knowledge where you can control, and you don't have the fear. You don't need to have them break your window. Okay. And the other thing is, when the cop, if you don't have a driver's license, you just tell them, yeah, I don't have a driver's license. then they diffuse everything. So and then you can ask him. They always ask the cop and tell him he doesn't understand the law and all this and that. But all you have to do is ask him. Do you have a warrant? Do you have a warrant? It's a yes or no for him. You have a warrant? I don't need one. Well, that means no, I guess. Okay, well, if you don't have a warrant, you know what? Let me ask you this. Do I have a right to remain silent? No, you have to talk. Oh, okay. Well, if I give you any information, do you promise me that you won't use it against me? What? I never heard that. What do you mean? Well, hey, look, if I got if I give you information, you go back and run it, right? That'd be a search, and you find out I got a parking ticket somewhere, a warrant for a parking ticket, then you're going to arrest me or some warrant, right? So I don't want you to use it against me because because this kid did that. I told him to do that, and say that. And the cop goes, "Oh, okay, no, I won't use it." So he goes back, he runs him, he comes back, he gives him his license, and he says, "Yeah, you got a warrant out for you. See you later."
Hey, go ahead and make a comment. Go ahead and make a comment, Harry. I mean, Richard.
Hello, everybody. This is Richard.
Hi, Richard.
Yeah, I just wanted to say concerning traffic courts. One of the things I learned a long time ago was I asked the judge when I walked in, I said, civil or criminal? He said, it's criminal court.
Yeah.
I said, so are you saying I committed a crime? He's saying, no, we're not saying you committed a crime. We're saying that you violated an infraction. And I said, well, People versus Sava, that's an appellate court decision here in the state of California, says infractions are not crimes. So therefore, the court don't have jurisdiction. They try to say it's a quasi criminal court.
Yeah.
You can file a motion to dismiss for lack of jurisdiction, subject matter jurisdiction, because first and foremost, you have to understand what a crime is, Sam, to be before this courtroom. Now, the court will say that the court will enter a plea. I've heard them say that before, where they'll say, well, if you're not going to enter a plea, because I can't make a plea. I said, where's the facts and evidence to support that a crime has been committed or I committed a crime? The court says, well, the court will enter a plea for you. And that's when you have to tell the court, I'll conditionally accept that if you act as my legal counsel, since you're going to enter a plea for me and protect all my constitutional rights. That's when it stops them. What I do is I don't like to go to them courts anymore. So what I do is I write to them a motion to dismiss for lack of subject matter jurisdiction, and I make no plea, and I give them the reasons why, the case law and the statute, and the reasons why that court don't have it. Because there's no verified complaint before the courtroom, so I don't go to court like on that. I usually get it dismissed that way when you put in a no plea, because you haven't committed a crime. There's no corpus delicti. There's no body of evidence of an injured party.
Hey guys, I have a question. When you do that, are you sending it as a private notice or you file it on demand on the record with their electronic filing system?
I would file it in the court in the case
Well,
itself.
let Richard go ahead and answer that.
Yeah, that's what, just like Sellam said, I just file it inside the court. I take the citation number and I have the pleading, which I'm willing to give to everybody, which shows everything like that. And then what you can do is you just file it in the court case and leave it there.
Yeah, but my question is, are you going into the court to file it into the courthouse, or are you doing it on their online system, or are you sending it in the mail?
Either way, I've gone into and filed it in the courtroom there, and you don't pay anything. I just filed it within the courtroom, and I've had people file it electronically. I've had William Wagner, the guy that's on that, he does those shows. He had one of his cases dismissed the first time that he filed it. The second one, they give him a little bit. They're still hemming and hawing and playing with him, but I've had a couple of people that just use it and they dismiss the case. My daughter had a 90-mile-an-hour speeding ticket, and I gave it to her and filed it, and she put it on the record, and they just ended up dismissing the case.
Okay, so let's so basically you did what I told everybody in the beginning. You can put in a motion to dismiss, or you can do a demur, because they're
Right.
basically the same thing. Now, see when you you're telling people you got the motion and here's why, and the court doesn't have jurisdiction because of this and because of that and all this case law. Okay, so that all can work, and that is definitely a way. But if people learn to understand what is going on, what that paperwork means, that's what we're trying to do with the court case, and the actual point, the authority, okay, that I would use to dismiss the jurisdiction is 853.9b of the penal code, which it says that the officer can write the officer's ticket is valid as a complaint if it contains facts upon which a warrant can be issued. Okay, and that's the crux of the matter right there. That's what gives the court the jurisdiction that you're talking about, subject matter jurisdiction. And whether it's criminal or civil, it's what they call quasi, and we call that a special proceeding. See, and it could be in the nature of civil and the nature of criminal, but it's a special proceeding, and that is a category that's quasi, that doesn't have any judicial authority, and so that's another reason why they don't have the subject matter jurisdiction. And so when we understand it from these different angles of why, because I don't use a lot of case law. I use the case law for purposes of backing up the authority, because the authority really is the statute. Okay, and case law, because but case law is, statutes are written from case law, and case law is what determined, but statutes also, case law is made upon statutes. So that's where they're authorities, but a statute is really overrides any court case. But the first argument I got into was kind of the same as yours, when I said, well, is that a crime? And then the judge, the female judge, she said, no, it's a public offense. And so then I took it in the direction of jury trial at that time, because I don't, not really into that. But I said, hey, look, I'll enter a plea if you charge me with a crime. But if you're not going to charge me with a crime, and she just said it wasn't a crime, then I'm not going to enter a plea. Okay, so we went around and around with that. And then lunchtime came, and so she put me in jail for 2 hours. And then she brings me back out. And I go, well, yeah, but now where are all my witnesses? And she goes, well, those five sheriff officers in the back are your witnesses. And I said, okay, well, then just charge me with a crime and I'll enter a plea. Otherwise, I'm not playing. And so then she says, okay, I'm going to enter a plea for you. Right. And of course, you objected and went in a direction. So she said, okay, I'm entering a plea for you. And I said, okay. And so as I'm walking out, remember, this is the first case, right? The clerk says to the judge, aren't you going to bond him? Right? Because, hey, got to have a bond on the first appearance. You got to sign to appear. And she says, oh, he'll be back. See, so really, I didn't have to come back. But she knew I was such a fighter and was so into fighting that I was going to be back there to fight. And that's another thing, we go in there and fight, but while you're fighting in a ring that's not official, and that's why another analogy I give, if you're going to go in a boxing ring and you're going to box these guys, well, actually, there's no one you're fighting. You're going to be fighting against yourself. So, but as you're walking up, you wait a minute, we can't go into this ring. The ropes aren't the right amount of distance between each other, right? They're supposed to be 12 or 10 or whatever it is, and you go, hey, they're not the right distance. Oh, we got to call the whole thing off. So that's just how I went through it, and so you can learn from everybody's experience. And when we say you got the motion to dismiss for lack of subject matter jurisdiction, I like the people to focus down on knowing that those are the reasons. And Sava and then Battle. You can go through and they talk about those, and yeah, it is a crime, but it's not a crime, and that you can litigate all that stuff, but you're not going to litigate 853.9b that whether this ticket is sufficient. The judge will make that decision, and it doesn't contain facts that constitute a public offense or a crime. So the court doesn't have authority from that perspective, from that angle. But there's a lot of ways to do this, because if they don't have subject matter jurisdiction, they don't have it. And another thing I'll tell you, you can go back on all those tickets that you were found guilty on and paid. You can go back and have those voided and get the money back. Dennis.
Yeah, go ahead, Dan. When when how do they do the hearing?
They don't.
I would go to the court and submit it in person and say, I'm here to submit this file in person and get a
Okay.
copy of it and make sure that copy.
Now, okay, so I see this is happening in Australia too. The cop writes the ticket and doesn't you don't have to go to court. They just send you the bill, and so what they're doing is they're putting us in the position. See, they're coming in and saying, give me money, right? Give me money. Okay, so what I would do is so at that point, then I would start an action against them. Say, call them in. See, and that's what the writ of mandate is, because what it is technically. See, remember, they didn't give you a hearing, they didn't give you a trial, they just found you guilty. Now that's what the cop does anyway on the street. He just finds you guilty and says, go over to the court and pay, or argue with the court. You're guilty, so you've already been denied your due process. So your writ of mandate, it would be on the cop or on the agency, the city. It's a parking ticket, and you bring them in on a writ of mandate, and because the First Amendment says the right to petition the government for redress of grievance. So your grievance that you have is that they didn't give you due process. Okay. And so you go to the court now and you say, you know what, the city didn't give me due process, and I want you, county court, Superior Court, to mandate them to come in and show cause why all their tickets, this one here, this one here, this one here, this one here, shouldn't be made void. And then they'll come, they have to answer to you. And what are they going to bring? What are they going to bring to show that you owe the money? They just got an allegation that you were parked there, and other information that we know. See, a traffic ticket, you were never served because the service of that ticket has to be personal service, and a ticket on a parking on a car. How do they know you were driving your car? What if someone else parked it there? Right. Yeah, but do they have evidence that you did it? Well, okay, so that's why they 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 charged you without giving you due process. The Fifth Amendment says no property shall be taken without due process of law. There's another point, another authority, because they want your money. That's your property. Now they're going to take it. When did they give you due process? Because someone else might have parked your car there. Just because your car was there or you want to register to you, that don't mean. Okay, well that's going to cause, that could cause a little rift, because to put in to file a writ of mandate, you have to have what's called a cause of action, just like they have to have a cause of action to sue you. Okay, that's the subject matter jurisdiction. So what is your cause of action in a writ? Is that you're beneficially interested. Saying that they might say, "Oh, you're not beneficially interested because it's your business, your association." But if you just say you are the owner of that business in your allegation, because your allegation doesn't have to be true, just have to be on there that because you're saying you're beneficially interested. You're going to end up paying it. So, but what gives you beneficial interest is you're the owner of that. Okay. Right. Yeah. Well, yeah, but that's because you didn't claim to the court that you don't have anywhere else to go. You say you can't. There's no other remedy you got. They just come and say, "Give me the money," and they didn't give you due process. And that's what we're going to learn in the next semester of our courses on the writs of mandate, and why, what the power of them are, and how they're used, and what the petition is, because it's not a complaint. Say, and you're just asking the court to make an order, and basically it's in the nature of an order to show cause. Yeah. So, but here the other thing is to figure out, to write that and do that and to put it all together, and you got to, because you're going to go for an ex parte hearing, and you got to, and you're doing all that. Well, by the time we get done with that, you could have paid all those tickets off, if you know what I mean, to pay an attorney to do that. I mean, in 1985 or something, I went to an attorney to ask him to write a writ for me because I didn't know how to write one. And he ran down all the things that he needed to do, that I figured out that needed to be done. He goes, I got to do this, got that. And then he goes, well, and that's going to be, $1,500. That was back in 1985. So, because what's the purpose of all court cases? Make the attorneys money. And so they just do that. So anyway, yeah, that's the whole goal. That's where I figured out the writs are the remedy. and we're not suing them under Title 42 because you can. I've settled a couple of Title 42 actions, but you got to settle because it's just going to cost a fortune. Because if you go to a jury trial, you got to pay for it if you don't win so much, and you really need an attorney to do it, and then you got to pay. He's going to take half of it or something, and more than half. And you litigate for a long time if you're any good, and then they can rule against you, and then you might have good grounds for appeal, and then take it up, and it's just the writ's a lot better. It happens, fast, and you're done, and you're not doing it. You're using the government to have them help you redress your grievance. That's the way I think it was designed. It's called an extraordinary writ. Extraordinary. Well, yeah, if it's extraordinary, you must be talking about me. Right? I mean, we're Americans. We're not sovereign in the sense technically, but we're exercising sovereignty because the government in law is sovereign, and we're using the government to exercise the power. We got paramount control of the Constitution and frame of government. That's when you know how that works, then we just exercise that sovereignty. We're not doing it. We're using the sovereignty of the government. So that's what, again, would to get into that, the wording, what's sovereign, what is sovereign, and because everyone gets off on a different meaning, but ultimately Jesus Christ is the sovereign, our God, that now to exercise the sovereignty of the secular sovereign. Well, who's the sovereign? The government is sovereign in that sense, and we're going to use that power and exercise sovereignty, not make it. But it looks like we could say, hey, we're sovereign. Yeah, we're sovereign in the sense that we have the power to use the government's sovereignty. So we're going to get technical on these things so that people understand and try to get. Yeah. 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 We asked the public defender to do a demur. He goes, "No, I'm not going to do a demur." But he was pretty good. He said, "But you can." A lawyer won't do a demur or file a writ in this nature. They can file writs, but not these types. Yeah, right on, right on. Yeah, that was good. There's a lot of ways to do this, and when you understand, there's a lot of options. And at some point, you know enough to be dangerous, and then, but it can cost you by doing too many options on top of options. Oh yeah, yeah. Bill, I've never talked to him, but I saw his website when he first came out. People, and there weren't a lot of people at that time. There's tons of people doing stuff, and but there were a lot of them, and I said, yeah, he's the closest to me. See, he doesn't quite do the writ the way I do, I mean, he's the closest, but he goes off on different tangents, and then I found out that he was a student of Roger Elvick, which I was a student of Roger Elvick. Yeah.
Is,
Well,
is, Bill, is Bill still teaching his had to get around court using his common law stuff. 'Cause I followed all that for years and years and years,
Yeah, yeah,
and I can say that it doesn't work.
yeah. Wow. Well, Bill, he just needs a couple tweaks. And the thing is, when Roger was teaching this stuff, he didn't he knew a lot of stuff, you know, and we were reading out of the dictionary and stuff, and he was learning as he was going, but he knew it, but he didn't put it on paper a lot of times. He'd just go in and challenge the judge and say, give me the order, give me the order, you know, release the order to me. You know, he kind of talk where they weren't really understanding. And even then you say, give me an order, give me an order. Well, you gotta, what was he didn't put it on paper. His emotion is to dismiss or the demur, because you can talk it and know it and everything, but the court doesn't have it on the record. So they can't give you an order based upon what? What's your order you want? The order of dismissal? Well, did you ask for it on paper? See, really, it's got to be on paper. And Roger knew a lot. I mean, he knew a lot, and and I was fortunate enough to take classes here in Sacramento from him.
Well,
Uh,
hold on. How much did Roger know? I mean, did he actually like know the law, like we understand it, or did he just like understand it the way you know we used to understand it?
well, see that the question. Well, the way we understand it now and the way we used to understand it is it comes around to the same, because he knew it as the common law foundation. And what's common law mean? I mean, people don't know. You know, it means a lot
Wait
of
a minute.
different things.
Wait. What you just said doesn't make any sense. What? How did he actually understand the law?
Okay, he understood the law by reading the law dictionary, okay, and getting and understanding the words. He was a farmer, okay. He's a farmer. If you know about anything about farmers, they have to know a lot about law because they have land. And he also was uh, close to Gordon Call, who was set off the Patriot movement in the early '80s. I mean, it was already going, but set it off when the cops up there in North Dakota stopped him and shot him, shot his kid, I think, or something, and then just for a misdemeanor warrant. And so so he learned about warrants. He talked a lot about the UCC, so he knew a lot about the process. And I think the way he knew a lot about the law was he had friends high up in the military that were giving him information, you know, kind of like now, you know, you got, what's his name? The guy they were going to put in jail, the guy, you know, the digital soldiers. God, I can't think of his name right off the bat. But all these big military
Which,
guys,
which guy was it? Who were you thinking of?
thinking of the guy who was that they went after as soon as Trump got in the first time, because he knew everything. Uh, you know,
Flynn?
Flynn,
Flynn?
yes, Flynn. Thank you.
Oh, okay.
Okay, and so
But
the military,
they got him on just some random charge, like for and
yeah, they
lying to
set him up. They
lying to
set him
the
up,
FBI.
huh?
Didn't they get him for lying to the FBI?
Yeah, yeah, they went in and told him that he didn't need a lawyer and that he could talk, and then they just set him up and got him on bullshit. And but you know, in 2012, a group of high military people, I think maybe before that, around that time, went to Donald Trump and said that they were going to do a coup on Obama because he was totally, violating the Constitution right and left, and that they, instead of doing a coup, they wanted someone to run for president that was clean, outside of the government, outside of all this stuff, that could do it. And so that they set up the plan. And so those guys that asked him, I think Roger knew people in that level, and maybe even some of those guys at that, and he was getting information from them too, about the law, about the Constitution, and then more. The UCC only came in the 50s. It's a commercial code. That again is not a civil or criminal thing. It's a quasi, it's not even constitutional.
It's for people in the merchant class to settle their debts ultimately.
Yeah, it's outside of the government.
Well, it's within the government because it's coded by the government.
No, it's coded by the Attorney General's office, and remember,
It's the California Criminal Code. I mean the California
Uniform Commercial Code. There's a federal Uniform Commercial Code, and each state adopts that and then puts it together their own way. Okay. Now it's adopted by the legislative. Now here's another point.
It's the California Commercial Code.
That's right.
Right. Okay.
That's not the commercial code for California.
Well, yeah, it is because
No, it's the California Commercial Code. It's not the California code for the commercial code for California.
Oh no, it is in fact the California commercial. I don't know what it is. It's
okay. Let me ask you
the
this:
Code of California.
how would you define, other than geographically, California?
There's a section in the code that describes it, or in the Constitution that describes it.
Okay, so so the Constitution is the foundation of California.
That's correct in terms of the government.
Okay, so that's right. The Constitution is the government. Now, if the Constitution is the government, which part of the government would you be talking about in any instance? Talking about, let's say, the commercial code. Are you talking about the legislative government, the executive government, or the judicial government?
Well, it depends on what I'm asking about it. If I'm suing about it, I'm going to the commercial code. I'm going to the courts. If I'm asking a question about it, I'm going to the government and asking the question about it.
Okay. So let's get back to this line of questioning. So it was written, right? It's a code that's written. So it's written by the legislature.
Yeah, it's written by the legislature.
Okay, stop right there. Stop right there.
Specific people.
Stop right there. It's written by the legislative part, not the judicial part.
Okay.
And not and now when it's written by the executive legislative part, the executive is the one who can construe what it means to execute it.
Right.
And when you go to court, the judge sitting there is an executive power, right?
Why is he an executive? He should be judicial.
Well,
I don't get it.
But what it should be is your opinion. But what he is he is an executive.
I don't understand that.
Well, okay, because he's gonna the judge. We call them judges, but they're really called magistrates.
Okay.
And a magistrate is the highest officer in the executive branch.
Executive.
Uh-huh.
Now, that totally misconstrues my understanding, because the magistrate is defined in the code as one of the judges, one level of judges.
Okay, yeah, a level of judges.
Well, but are you saying on paper the magistrate is part of the executive class?
Yeah. And so all these courts are basically executive courts. And sometimes we call them Article 1 courts because the legislature creates all the courts except the one court. Which court does the legislature not create? The Article 3 court. That's part of the Constitution. So, and in the federal Constitution, it says that Congress shall from time to time create courts. And they've created all these courts because the judicial power is vested in the one Supreme Court.
Okay.
That's where it's vested.
I see. So even though the legislature creates the court, it's still a legislative court.
Yeah. But you can bring judicial power into that court, but you have to bring it in. And the only one that can bring it in is
Is through the writ of mandate, right?
yeah. Or if you're a defendant, you can move to dismiss or demur on the grounds that they're not, because their process is never sufficient to do a judicial action. Remember, because none of the things they're doing is criminal. Even if it's an actual crime, it's come in by statute. They statutarized murder, even though it's a judicial common law crime. But they don't charge it that way because, and you can. I mean, but and they used to when they made the wife testify. Remember, they had to bring charges. The cop couldn't bring the charge himself. So to bring the charge, you need the person. That person has the judicial power because they're not corporate. So I studied these things, and then when I explain them, sometimes the words, I don't use the correct word, or we don't, some doesn't understand the word in the right context, and so that's what we need to work on, how we think. And guys like you, Sellam, you get it because you do computer thinking. I mean, you think everything's got to line in a logical manner. But when we use the word jurisdiction, that's a broad term.
No, I maybe I understood this before, but
Yeah.
The idea that the courts are legislatively induced is interesting, because the legislature is creating. Yeah, the legislature basically creates the. Yeah, I don't think I ever understood that.
Now, here's the way I pick when I used to draw my drawings in the beginning when I was teaching the separation of powers, is that if you got the legislative, executive, and judicial branches of government, right? Okay. Now, under them, not connected really, but are what's called agencies, and the ultimate agency is called the Department of Justice. Okay, the Department of Justice is not the Article 3. It's departing from justice. And that's where they put the Attorney General's office and the Department of Justice, and then they act like they're the court, the judicial court. But they really are created by Congress. Congress created the Department of Justice. Did you know that?
Oh, you're asking me, Congress created the Department of Justice?
Yeah. It's not a constitutional entity. It's ultra vires. It's outside the Constitution. It's unconstitutional.
Right.
All the agencies are unconstitutional, or ultra vires, as they say in a corporate status. So that's why all the actions that are going on, that's why don't bring the Constitution in. But you can bring the judicial power in, but it applies to all cases, law, and equity. And a case is where the government's involved, and a suit is where is like civil things, and where the government really isn't involved. They're not prosecuting. Who's the real party in interest in a traffic ticket? Nobody. No judicial power. An agency outside the Constitution. So yeah, that's why when we say the government, we got to dig deeper. Are you talking about the legislative power, the executive power, the judicial power? And it is the executive power who sits on the as the judge, because the attorney, the prosecuting attorney, when he brings the case, he's representing the statute, right? Doesn't he say, here's the statute that the defendant violated, right? Article 1. He represents Article 1. He represents the legislature. And he takes it to the judge, who represents the executive. And guess who represents the judicial? The defendant. But if you stick an attorney in there for him, then that's a legislative guy. And he's on board with the guy that's prosecuting. And so they come to an agreement, and then the judge, who's the executor, he executes the orders. He writes the order, whatever the two parties agreed to. So everyone agrees. That's why they say a lot of these guys in jail, they agreed voluntarily. Yeah, their attorney helped them agree. That's what the attorney's there to work through, to make sure that they get the conviction, and without any technical problems. So if there's technical problems, then there could be an appeal. But that's just going up all through the legislative court, and not the judicial court the way we think.
All right. Does anybody else have any questions, or should we go now? Or we'll wrap it up. Does anybody else have any more questions?
Not questions, but I was going to say this, because a lot of times what happens, like you said, that when you go into a courtroom, if they appoint you an attorney, they will always waive all your rights to a speedy trial, and that's something you should never waive. The other thing is, if they do appoint you an attorney, you should say that you'll conditionally accept him as long as he does not waive any of your constitutional rights. and they won't sign that, and they won't do that. You've got to stand strongly on that, because they will waive all your constitutional rights and also to a speedy trial when you go inside there, and they can't move forward until they accept that.
Yeah, that's right. Well, see, I found that, you know, if you stand strong
Mm-hmm.
and you keep standing strong,
Mm-hmm.
you're going to beat them. You might end up standing and getting tired and weary and dreary, but you stand, as you keep in there, you'll beat them. But the minute you give up, you're going to lose.
Because you don't understand. She always says say that because they're going to ask if you understand the nature and cause of that, or actual what has been filed against you. You always state that you never understand the nature and cause of the action filed against you, and you've never seen where's the valid verified complaint by the injured party. You know.
Well, see that you're right, but when after we have my course,
Mm-hmm.
then you'll be able to explain what it is you don't understand of the nature and cause of the accusations. You'll go, well, I don't understand. Bing, 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 and bing. So
Yeah,
explain it to me, Judge.
absolutely.
Yeah. So you're right. You're right. You stand up and you can stand on a lot of things, and you'll win. But I stood so long on stuff, and I got tired. and a lot of times I spent more money than the fine. You know, but that's education. So, and that's really what we're looking for, people that'll do that, because once we learn how to do this, we learn the fundamentals and we learn an understanding of the basic structure, then we're going to be able to file these writs, the writ of mandate, the writ of habeas corpus, or, you know, but the writs are all basically the same. We're gonna file writs just the way that cops issue tickets. You know, 1 page, send it in, have the hearing, bring them in the next day, have them answer. Bing, bing, bing. So I want to get enough people that are that will be members of what I call the pro per platoon. So we're all in there, we're on a platoon, so we know what we're doing, and therefore we can all get our own, platoons or troopers, and then start at every little in every town a little group of pro per members, and then we can help each other and help people with their tickets and beat them. You can help them with everything, with the unlawful detainer, with the mortgage deal, you know,
So
because
speaking of the course, it starts tomorrow, Wednesday, November 5th, and it's from 10 a.m.
yeah.
So a.m. 10 a.m. to 11:30 a.m. and it's live on Zoom, and you will you how do you call it, you decide how much you're going to pay. So you just decide, and then
Well, you go, and it's free, and if you want to donate, you can donate at any time.
oh, okay, well, there you go.
Yeah, it's all open. I don't know if Max got an invitation, if he wants to come. I'm putting out invitations, and a lot of people might not be able to make it. So we're going to put up the recording so you can have access to the recording.
Mhm.
Because, you know, if you're interested in this and you want to learn it and you get it, it's invaluable. You know, and a lot of people don't have money. But if you don't have money, like I didn't have money doing this stuff, my dad paid a lot for the seminars and stuff that we went to and the classes I took, and we went. And I didn't have much money, but I'm trying to learn it, and I'm asking questions. And if you want to learn it, you know, then and don't have any money, well, then come on in and learn it, and you can pick it all up and do it and figure it out like I figured it out, and then do it. You know, it's not that you're paying me to, you know, to teach you this stuff. I'm just putting the information out. But now, if you need private help and you want me to help you put a writ together, then that's different. You know, but if you can learn to put a writ together, believe me, it took me a long time, and the only way I figured it out was the form was in the 80s. My dad photocopied the book on writs and writ mandate and prohibition. It was what's the blue books they're called? I can't think of it right offhand. Anyway, and he photocopied the whole thing, and it had all the forms and the grounds that you can do the writs on. And when I went to look it up later on in the library, I couldn't find it. And then I finally found the copy he gave me, and then boom, I got it. But it may be out there.
You're talking about the pleading papers?
Well, it tells you like you can get the pleading papers, which I didn't have that I got from there. But it also it tells you, like if you're going against a clerk, if you're going against a judge for abuse of discretion, if you're going against the city council, public officials, how to frame the argument, and
Yeah, that's I forget the name of it as well.
Matthew Bender forms and pleadings.
Oh, okay, there you go.
Yeah, and so that had it, but they changed it up, and it wasn't the same for writs because they conflated a writs with different meaning, and different, and they just conflated everything. So you had to really know what it means. Just like when we say the government, to me it means the Constitution, and then I have to break that into 3 parts, separate and equal parts. So we have a tripartite state or constitution. Yeah. So okay, that's what we're going to cover, and yeah, no charge, whatever. And I don't know if Max got an invitation. If he wants one, like he can just send a email to Equity Center 17
Yeah, he
at
got one.
gmail.com. Okay.
Yeah.
All right. Awesome.
Any
Thanks.
more questions? Any more questions?
Thank you.
You're welcome.
Thank you, Richard, and all you guys.
Well, Zeke is mostly going to handle it. I'll be on at least the first time. Yeah.
Yeah. And so, I just went off today on this, and next time, I don't know what we'll talk about. Maybe people have questions, because really we need questions to what to talk about. And that's why we end up talking. I'm trying to create questions for you guys, because that's the key. You need enough information to create a question, because people don't know what to ask. And then they ask the questions. You wouldn't believe these questions on Facebook these guys ask. Well, what do you think democracy means? Okay, well, I don't, it means, I don't know. I don't know. What does it mean? What do you think about the Whiskey Rebellion? Well, dude, I'm a legal analyst. Okay. I analyze the legal process and the legal papers, not theory and political theory. I do have ideas on politics and stuff like that, but, that's, to me, I didn't vote for years because that's not what I'm into, even though I was on the Libertarian Party. My mom was in the Democrats. Yeah, I there's a place for all that. I didn't vote because I vote with my paper, I vote with my pocketbook. That's how I always voted. But yeah, I do see the value in voting these days because of the rigging of the whole thing. So, but yeah, I stick with a legal analyze. And let's break it all down to the courts, and you get the remedy in court. And one thing Roger said, you can do whatever you want if you can take the heat in court. So that pretty much says it.
All right.
Thanks, Sellam. Thank you very much.
You muted out, but I'm not going to continue at this point because I'm not ready to do anything with it. So unfortunately, but we'll see how it goes.
Yeah, well, Sellam, can we say we'll do it next week? Because after tomorrow, I'll tell them that we can meet on Tuesday night. Or I can set up another, or I could set up my own, actually.
Well, we can do it if next Tuesday if you want to do it, but you just have to let me know.
Yeah. Okay. Well, it might take a while to get people back, you know. I mean, Catherine's not here, and a lot of people, don't, really. We'll see. We had a few more people. Yep, yep. So let's try again next Tuesday and put it out, and then go from there. How about that, Selem?
That's fine. We'll do
Okay,
that.
awesome.
Okay.
Yep.
Well
All right.
then, good
Good
to see
night,
everybody,
everyone.
and
Thank you. See you
yeah,
tomorrow.
good to see everybody. We'll see you next time. Take care.
Right on. Thanks.
All
Bye
right.
bye.
Have a good night. Thank you.
You're welcome. Thank you.